named you just in time. TYME, so your name's memorable. Rhonda Ives is your attorney.
Yes, sir.
So I'm going to show a plea of not guilty. I'm going to appoint Rhonda Ives. And set an attorney pretrial.
Right from the start, this courtroom sets a serious tone. The judge isn't just processing another case, he's evaluating risk. A defendant facing multiple issues, unpaid restitution, and repeated legal trouble is now standing in front of the court again. And when the judge starts talking about bond and public safety, you know this isn't routine anymore. This is about prevention. The court isn't just reacting to past behavior, it's trying to stop what could happen next. So the question is, how far should a judge go to prevent future harm?
For Friday, you're going to be here anyway. 2/20/26 at 8:30. 5th 2610 SD. How'd you get here today?
My mother drove me.
I bet she was happy about that.
Yeah.
Thinking about
This moment hits hard legally. The judge openly acknowledges the danger of releasing someone on bond when they're already facing serious driving-related concerns. That's a key principle in law: public safety over convenience. Bond isn't just about letting someone go. It's about trust. And when that trust is questionable, the court tightens control. Add in unpaid restitution and prior cases, and suddenly the defendant's entire history becomes part of the decision. So ask yourself, should past behavior weigh this heavily in present rulings?
setting your bond at about $10 million. We don't look very good if somebody kills somebody on a drunk driving accident while they're out on bond for drunk driving. So this is something we need to pay attention to. I don't know if you're sobriety core material or what. The earlier case, not to mention, you've got thousands of dollars of unpaid restitution in a malicious destruction of property case, and you've got multiple other unpaid, oh, I guess they're all set. You got an unpaid disturbing the peace from 2020. So there's a high likelihood of jail in your future. But you got competent counsel, and did they put any bond conditions on your second arrest?
I believe so.
No alcohol, test as
Yeah.
directed?
I don't know about the test. I just know.
Now we see the court shifting from warning to control. Drug and alcohol conditions are being reinforced, testing is on the table, and compliance becomes the central focus. This is how courts try to manage behavior outside the courtroom, through conditions, not just punishment. But here's the interesting part. The defendant admits marijuana use while claiming sobriety from alcohol. That contradiction matters, because in court, partial compliance still raises red flags. So where should the line be drawn? Strict zero tolerance or realistic expectations?
Well, no alcohol.
Yeah.
I'm going to test you, or Judge P will test you when you
That's
come in
fine.
here on Friday. If I gave you a test right now, what would it show?
No, I'd pass. I haven't drank since the second charge.
How about marijuana?
I'd fail for that.
Yeah, I bet. A high percentage of our drinking driving cases probably also have marijuana in their system, but we don't always test for that. Anyway, it's time for you to get a handle on what's going on here. I'm going to send you out with the court officer. We're going to get an attorney appointed to represent you, the same one, and you're going to deal with both of these on Friday. All right, you continue to comply with the terms of your bond, and I want you to start paying on all this unpaid stuff. We can wipe some of it out with jail, but we can't wipe out restitution. All right, you go with court officer.
Have a good day.
All right, we're working on it. Robert Alexander.
Morning,
Good
Mayor.
morning.
Dan Schwam, P61476 on behalf of Mr. Alexander.
All right, give me that again.
Dan Schwam, SCHWALM, P61476.
Good morning. Welcome to Centerville.
Your Honor.
Have we met before?
It's been a couple of years, but yeah, I was working as a prosecutor in Calhoun County, and we had a special sentencing.
Oh, yes, I
handled the
did.
Contractor case. I don't know if you remember that one.
Yeah, well, the guy's still on the lam.
Yeah.
We never have caught, I thought your name was familiar, but I haven't. I still have the file. He's still AWOL with open warrants.
Doesn't surprise me.
I'm retiring in December. I hope they catch up with him before then.
Congratulations.
Well, I have mixed feelings about it. State of Michigan tells me I have to retire. And somehow I've lost your client's file here. I haven't lost it. I don't have it. So what the deal is, why don't you guys have a seat? It'll be more comfortable. That'd take me a minute. Well, it's in the AS400. It's in here. I don't think I'm crazy. Don't have the file. I don't seem to have Robert Alexander 26193 FY. He's not on the list. He is in the AS400 and on base, but he's not here, and I don't have his file. Robert Alexander 26193 FY. Let's click into it.
This is where the legal complexity ramps up. What might seem like a minor act, interfering with a phone call, suddenly becomes a 10-year felony. That's the reality of how laws are structured. Some actions carry heavier consequences because of the risk they create, not just the act itself. And alongside that, there's a domestic assault charge, adding emotional weight. The judge even acknowledges how unusual that difference is. So here's the question. Does the punishment truly fit the behavior in cases like this?
Mr. Alexander, you're charged with interfering with a crime report. It's alleged that on or about February the 7th, that you interfered with Madeline Simpson who was attempting to report a crime committed or attempted by another person attempting to commit domestic violence. The way this is charged, it's now a 10-year felony. It's often interesting. Assaulting somebody is a 93D misdemeanor. Interfere with the phone is a 10-year felony. Anyway, you're also charged with domestic assault upon Madeline Sue Simpson. The fact that you wore a tie and a coat shows that you show respect for the process. That doesn't happen much anymore.
Yes, Your Honor.
Do you still live at Marathon Drive?
No,
That's where Miss Simpson is?
no. She's in 705 East Broadway,
All right, well, don't tell me anymore, but where are you staying?
349 Loveport.
All right, just tell me the town.
Oh, Benton Harbor.
Okay. Because this is a felony, I don't have jurisdiction to take your plea. He's not on the list, even on the list, but what would be the prelim date and PEC date?
Your Honor,
Yes,
the victim is here on that case. She wanted to address the court. I don't know if you'll take her at the moment or not. She wants to address the no contact order.
all right, Miss Simpson, would you come up to the podium? Excuse me, not as worth than watching somebody blow their nose on video, but I've been doing that a lot lately. Are you Madeline Sue Simpson?
Yes, Your Honor.
You're the complainant in this case. What would you like me to know?
Now we move into one of the most delicate parts of the courtroom: victim input. The complainant steps forward and asks for the no contact order to be lifted. That's powerful, because legally, the court must protect victims. But what happens when the victim doesn't want that protection? The judge explains why these orders exist: safety, preventing manipulation, and preserving testimony. This is where law and emotion collide. So what should matter more? The victim's request or the system's responsibility to protect?
I just want the no contact order to be lifted and that I don't feel unsafe or harmed by any means.
I don't want your street address, but you're staying in Three Rivers?
Yes,
And he's in Benton Harbor? Do you have children together?
no, we are married though, so I have a son, he has kids.
But you don't have any children together?
Not together, no.
Okay. That's often an issue: custody, visitation,
Mhm.
that sort of thing. It's a standard condition in assault cases, even regular domestic assault cases, of no contact. Certainly in a felony case, I don't know the facts. In fact, I just opened this file like 1 minute ago. I also go by the theory that you don't know what you got till it's gone.
Mhm.
Making you not have contact with each other makes you appreciate how much maybe you ought to respect each other when you do have contact. So there are several reasons. The primary reason is to protect the complaining witness. You don't want people getting re-assaulted, and unfortunately it happens more often than we like. Secondly, you don't want the complainant either overtly or covertly trying to alter your testimony.
Mhm.
I love you, I'll never do it again. Please let me come back. Or I'm gonna hurt you worse if you testify, both of which happen again more often than I'd like. So I will note that you're requesting that bond be amended, but I'm leaving the no contact provision in place for now. This isn't gonna just sit idle.
Your Honor, may I add something just that may impact your decision?
Yes.
And just like that, everything shifts. The prosecution offers a deal. Drop the felony. Resolve the case today with a misdemeanor and a deferral. This is a huge turning point. From a potential 10-year felony to a chance at no conviction if conditions are met. That's the power of plea negotiations. It saves time, reduces risk, and gives defendants an opportunity to move forward. But it also raises a key question. Is this justice or just efficiency?
So my client, since this incident, he's actually started to attend anger management courses on his own. I have a letter that from Kieran King, who's a licensed social worker, that he's met with her. He's going to continue to meet with her. He's taken this very seriously. I think if the court were to allow peaceful contact, he has no criminal record at all. I don't think there's going to be any issue whatsoever in this case. He's very serious about trying to rectify the situation and the argument. If you look his name up, you won't see he's ever been in this court. At this age, you would see him if he was a troublemaker. He's definitely not.
Judge,
Yes, I'm sorry, I usurped your seat, but thank you. Everybody's in the wrong spot, but yes, Mr. Josh Robert is here from the prosecutor's
so as
office.
everyone's been talking, I've had a chance to look over the file. If the defendant wanted to enter a plea today to DV first with the deferral, be placed on the probation, he can continue in that counseling that he has. We'd have no objection to that. The case could be resolved and they could move forward. We dismiss the felony count.
All right, it's good to have somebody with authority in the room. Thank you, Mr. Robert. Why don't you sit down for a minute, Ms. Simpson? All right, what you're charged with is a felony punishable by up to 10 years in prison. And an ancillary charge, probably the more germane charge, domestic assault or domestic violence. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Your lawyer says you have no previous criminal record, and I guess I'll take that at face value. Mr. Robert, the chief assistant for the prosecutor's office, says we can take care of the whole thing today, including the bond issues. If you enter a plea of guilty to domestic violence.
This is the judge laying out the full picture. Rights, consequences, firearm restrictions, long-term impact. It's all on the table because once a plea is entered, there's no undo button. And notice how carefully the judge explains the benefit of a deferral. Complete probation successfully, and the conviction disappears from public record. That's a life-changing opportunity. But it comes with strict expectations. So ask yourself, would you take this deal or fight the case further?
Misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. They also do not object to a domestic violence deferral. There's a special statute in domestic violence cases, and your lawyer is well aware of it if he was a prosecutor, that allows the prosecutor in their discretion to allow the court to defer the conviction. You're already in a domestic violence treatment class, which I would order. If you were to plead guilty to this charge this morning, the complainant is here, I could do the sentence today. I could put you on probation, or do you complete your domestic violence treatment program with other conditions? Says you were drunk, there's going to be a no alcohol condition. If you successfully complete the probation, the charge could be taken off your record and there would be no record of conviction. I could also lift the no contact provision because the complainant is here, so I don't have to wait 10 days to do the sentence. And she wishes me to lift the condition. So we can take care of the whole thing right now. It's a very busy morning, but we'll make time for this. Mr. Schwalm, you wish to have a chance to discuss that with your client?
I would, yeah, there's a lot of ancillary consequences, gun rights, etc. And I'd like to go over those pros and cons with him before allowing him to answer the question, if that's okay.
No, I don't.
Heard of this office,
I don't mind at all. Now, if you get convicted of domestic violence, it goes on your record as a criminal conviction. Prohibit you from using or possessing a firearm for 8 years. That's important for a lot of people. If you're in the military, if you're a police officer, if you just like to hunt or shoot, you can't use a gun. If you complete this probation, that firearm provision does not go on your record, and there's no public record of conviction. The state police keep a record because you only get the deal once. But if someone to run a criminal history on you, it wouldn't show up. So Mr. Schwalm is cautious and he wants to talk about this with you. And I don't have any objection to that. So why don't you guys go discuss Mr. Robert's plea offer, and we'll see what we're going to do next.
Thank you, Your Honor.
All right, sorry that one fell between the cracks. It was on the list, wasn't on my list, and I didn't know it was there, but we did it. Cody Ellis.
Oh, no.
Ms. Camfield, are you here on PECs too, or on?
Kind of everything. I have a PEC.
You're always kind of here on
I
everything.
have a PEC and I have some pre-trials this morning.
All right, thank you. Let me know if you need anything. Good morning, sir. Are you Cody Jake Ellis?
Co-tie, but yes,
Co-tie.
sir. Good morning.
I'm sorry, your name's probably been mispronounced all your life.
Yes, sir. I get it a lot.
That's on your mom and dad, but I'll try to remember. Kotai Ellis.
I got weird heritage.
Okay, all right. I guess we all do. You're charged with assault and battery. Take a look at your case. We're going to put you in the back room. Mr. Ellis, you're charged with assault and battery. It's alleged that you assaulted Bradford Smith in Three Rivers on April 25th of 2024. This is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. This was authorized by our old dear friend Melissa Halleck. And it happened 2 years ago. At the probation center. Heesh. How did you come to get arrested recently?
I ended up having a child support warrant that I went in to take care of. And on top of that, they told me finally, I knew about this charge, but it was always I had to appear in person, but I lived 2.5 hours away with no vehicle at the time.
Where do you live now?
I live in Somerset.
Somerset, Michigan?
Yes, sir.
Where's that?
About 2.5 hours away. It's about literally 15 minutes further than Litchfield.
Oh, it's in Hillsdale County?
Yes, sir.
Never heard of it. Mr. O'Bear, I'll put you on the spot again. Is this the kind of thing you would take a disturbing the peace to resolve it?
Sorry, Your Honor, I wasn't listening to what this defendant's name is. I can look it up quick.
Coty, K-O-T-I-L-S, E-L-L-I-S. You didn't know I'd be drawing you into this. Reminds me of the dude telling the Malibu chief of police, I'm sorry, I wasn't listening. Just before he throws a coffee cup, it hits him in the head.
If I can, may I
Don't
speak?
say anything yet.
Yes, Your Honor, I would take it as during the piece.
Here we see another example of courtroom efficiency. A 2-year-old case gets resolved in minutes. Charges reduced, plea accepted, fine set, and the case is closed. No drawn-out trial, no delays, just a fast resolution. This is how courts manage heavy caseloads. But at the same time, it raises a bigger question. Does speed come at the cost of deeper justice? Or is this exactly how the system should work?
All right, once again, it's good to have somebody with authority right in the courtroom. This is 2 years old. You got in a fight with another guy at the probation center. the prosecutor would reduce this to simply disturbing the peace, which is an old-fashioned simple misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. Normal fine for that is $200, and you've posted $100 of bond. Are you willing to plead to disturbing the peace?
Yes.
Thank you, Mr. Robert. All right, disturbing the peace, I say this about every day. It doesn't matter who was right or wrong or who started it, but was there a quarrel, argument, or disturbance in a public place? Did you get into an argument with Brad Smith?
Yes, I did.
What was it about?
Just different views.
All right. How long were you in jail before you posted bond?
5 days.
Oh, boy. All right. He said you put raw eggs in his shoes and then.
That was all after the fact.
All right, but anyway, scrambled eggs isn't so bad, but I hate when you put raw eggs in my shoe. All right, so did you end up socking each other?
Yeah, yep. Caught him in the bathroom and yeah, I assaulted him.
All right, what are you doing now?
What is that?
What do you do now?
I work and raise my 2 little girls in cage fight. That's all I do.
You raised the girls in cage fight at the same time, or?
No, not at the same time, but
All right. Are you off paper? Are you off paper?
Yes, sir.
Probation parole? All right. All right, I gave you 5 days jail credit, 5 days, $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. That's $200. You posted $100 of bond, so you owe $100. Can you pay that today, or do you need time to pay it?
I can literally pay it at the beginning of next week.
All right, I'll give you some time to pay it. You can't got this much of it resolved. You want to finish it. All right, now, I just took your plea, but I didn't advise you of your rights. Do you understand that by pleading to this charge, you give up your right to have a trial? Do I have a advice of rights? Yes, giving up all these rights on your advice of rights.
Yes, sir.
Very good. I'm gonna give you 30 days to pay this. I'll give you till March 30th. $100, 330, 25, 26.
This matter is over and done with. That line says everything. Finality, closure. And for the defendant, a chance to move on, if they follow through. But notice the pattern throughout this courtroom. Compliance leads to resolution, while failure leads to escalation. It's a system built on behavior. The court gives opportunities, but only if you meet it halfway. So what do you think? Is this system fair, or does it rely too heavily on quick judgments?
There's some instructions on the inside. I want you to pay that. And this matter's over and done with. It's going to show us disturbing the peace. Good to go, sir.
Thank you very much, sir.
Okay. All right, that's good to resolve that all at once. Good morning, man. You're sitting on the attorney's side. You have to pay extra to sit over there, especially if you're from Colon. All right, let's see who else is here. That's everybody that was on my list. Doncha Gaddy from Kalamazoo, 252688, failed to appear, and there is currently an open warrant. That's on a retail fraud conspiracy. Warrant will remain out. co-defendant Naisha Pratt also has failed to appear. All right, so we're ready to go. We've got 3 sentences set for this morning. Sometimes I'll try to fit them in on a Wednesday morning if we have time. And we do. We have a domestic violence case here with Mr. Gibson. And then we have another matter. And then one with Ms. Strong. This is Cheyenne Marie Zarnecki. That's you?
Yes.
I was gone for a few days and I reviewed this case again yesterday when I came back. And then I looked at it again this morning. This is a prosecutor's offer for a deferral in a domestic violence case. This happened in January. You and your partner have both been drinking. Alcohol is kind of an underlying pink elephant in the room here. But otherwise, as far as I can tell, you don't have much of anything in it. There's criminal history, criminal record, and you appear to be appropriate for our women's anger management deferral. But Mr. Gibson, what would you like me to know?
I guess the defendant, I think there was alcohol mentioned in the report, but I don't know if the defendant believes that she was intoxicated.
No, I was not.
Well,
Okay,
he certainly was.
Yeah, I let them know that he was. And they
But the
didn't.
report says, get him back into this file. First, there's the bond information report and then the whole report. Both parties indicated that Zarnecki started the altercation by placing a hand over Farmer's mouth and squeezing his throat. Farmer and Zarnecki were in a dating relationship for 5 years and had a child together. Both parties stated Farmer was intoxicated and a nearly empty 375 milliliter of vodka was at the scene. So he was the one drinking the vodka, not you.
No,
All right.
I barely drink.
All right, I had a broader attribution in that case. All right, well, go ahead, Mr. Gibson.
thank you. So the defendant is employed as a security guard. She's only 22 years old. And so I believe that, with this situation, it was an unfortunate situation, but I believe that she can be, in a sense, she can learn from this. And I believe that the deferral is appropriate here. I would ask the court to sentence the defendant to probation. And if she needs, if there are any concerns about issues such as substance abuse, then I'm assuming the probation department would be able to address that. But I don't believe that alcohol is an issue with her, at least during this incident. So thank you.
Ms. Campfield, thank you. I don't know if you were involved in this or Abigail was, but at the pretrial, this is again pretty fast. This happened in January and we're doing the sentence in February, and she accepted responsibility. The prosecutor did not object to the deferral. I set it out for at least 10 days to get input from him and get the whole police report. I'm assuming still you don't have any objection to a deferral.
Correct, Your Honor. We don't have an objection to that. And Mr. Farmer has not activated his rights with or office or responded to the letters we sent for pretrial or sentencing. I do note that he was injured. He did have some scratches and whatnot from the altercation. The defendant indicated that she had had some bruises on her arm from the altercation. So I do think in this particular instance, due to her age and lack of history, that the deferral is appropriate. Can assist in learning communication skills and triggers, and then how to cope with a lot of the strong emotions that come with trying to co-parent a child, a toddler in this particular instance. And I will note that the toddler was present during the majority of this altercation as well, which is concerning. So I think the counseling would
Well,
help.
part of what started the fight is he was gonna care for the child and brush their teeth or whatever while he was drunk. And then it all kind of went downhill from there. How old is your son?
He's 3.5.
All right. Now, I had a no contact provision in here. You guys were living at the apartments, what used to be known as Waterfront. Who's still there?
I am. He moved out the day I came back, or was coming back, and got out of jail.
Where does he work?
I'm not sure if he has a job or not yet, but he ended up moving with one of his friends up north in Grayling.
Oh, he moved to Grayling?
Yeah.
By the end, this courtroom session tells a clear story: accountability, opportunity, and consequences all working together. Defendants are given chances through deferrals, reduced charges, and structured probation. But those chances come with strict expectations: no violations, no excuses. The judge balances law with practicality, offering pathways forward without ignoring responsibility. And that's the real takeaway. The system isn't just about punishment. It's about what you do next. So, what do you think? Does this approach truly help people change? Or is it too lenient? If you found this case as shocking as we did, be sure to like it, share your thoughts in the comments, and don't forget to subscribe for more amazing courtroom analysis.
Ms. Zarnecki, it would be very good if you completed this probation.
Yes.
It entails a referral to the Women's Anger Management class, the Women's Domestic Violence Treatment Program. I started it when I was prosecutor a long time ago, 35 years ago. And now I use it all the time as judge. Almost to a person, the women tell me that they thought it was valuable. They liked it. They got good input. Very often, women that are charged with domestic assault are also victims of domestic assault. And so we try to explore that whole dynamic. Now, I told you at the time of the plea, I'll tell you again, if you hold up your end of the deal in this, the charge will be taken off your record and there will not be a public record of this conviction. Do you understand?
Yes, sir.
All right, I'm going to put you on a 12-month probation. I believe you got 1 day of jail. Well, 11 days jail credit, 1. Of the 11 days ordered, 10 are deferred. You're not going to do any additional jail time if you do what I ask you to do.
Okay.
I'm going to make the fine 0. There's a $75 crime victims' rights fee and a $50 state minimum fee. Those are required by state statute. There's a $150 attorney fee. There's a $480 probation oversight fee to pay for the class. You can do this probation in half of the time. So a 12-month probation, you can complete it in 6 months, which will save you $240 in oversight fees. Some of it depends on when the class is eligible. I had a guy this morning. He was 5 classes into his, I think, 26 classes. And he was enjoying the men's domestic violence program. I'm ordering that you go to the anger management counseling, no assaultive or threatening behavior, no drugs or alcohol. Test if necessary. I don't think for you it's a big issue, but you're not allowed to use any marijuana or use any alcohol while you're on this probation. I'm lifting the no contact provision. You can talk to each other. But you can't engage in any assaultive or threatening behavior. Now, has he had any contact with your son since he left?
Yes.
Okay.
My son has an iPad that he will call.
Does he My little 3-year-olds are using iPads.
It's
Um,
only for like an hour or two a day. I don't let them play on it all day.
well, I'm not being critical.
Yeah.
It's just, they were a lot smarter than I was 3.5 years
Yeah.
old. And I understand the whole phenomena. My grandkids would stay glued to it if even my 2-year-old granddaughter is intrigued by it. What shift do you work?
I work first shift, so I.
So are
get
you
there
missing
at-
work right now?
Yeah.
All right, well, these classes are mostly in the evening.
I get out of work at 2 PM every day,
What time do you go in?
6 AM.
This is at American Axle?
The Morgan Olson's.
Oh, Morgan Olson.
Sturgis.
So you drive from Three Rivers to Sturgis every day?
Yeah,
I had it mixed up. Where are you from originally?
I'm from Manistee.
I think you told me that. How did you guys end up in Three Rivers?
Well, we moved around a lot, bouncing from my family, and then last place we moved into was with my aunt in Shipshawana, Indiana, and then I was finally able to get into my own apartment in Three Rivers.
Well, it's not a bad place to be. Those are pretty nice apartments. Who's doing your childcare?
He goes to the Carol Shippey Head Start for now,
Okay.
and then I have a friend that watches him for the couple hours that I go to work, and then she takes him to school. And then I get out of work just in time to pick him up.
All right, well, you got a system. And I would like to see you complete this and have this charge taken off your record. So I want you to take this form out to the counter. And they will get you plugged in. And I want you to hold up your end of the deal. If you can get this done in 6 months, I'll discharge you from the probation. Charge will be made non-public.
Yes, sir.
All right, good luck to you.
Thank you.
Paul, you've also got Alexander Pappas. If he's here early, we can start early.
Okay, I'll see if she's out there. All right.
Excuse me. I end up using a lot of these Wednesday slots for Casey Strong because she can't do Mondays because of the Kalamazoo obligations, but I only have one today. And I was gone for a few days, which kind of jammed up some of my sentencing spots, but this worked out fine. We got plenty of time to do 3 sentences. I hope that young lady completes this.
Your Honor, did you end up doing Mr. Sovey's sentencing this morning?
I did.
I was next door.
Well, it was a no insurance case.
Okay.
And he has a bunch of tickets, but he'd get them at the same time and then he wouldn't answer the civil infractions. So they all got defaulted. He's on a payment plan. I deferred it to see whether he'd made his payments, and he made a payment in December, January, and February 19th, and he was going to make a payment today. So I just gave him an additional fine and put it as part of the payment plan.
Gotcha. Thank you.
I think he's lost his license from some Kalamazoo stuff, but he said he's not driving anymore. His sister lives in Constantine. She drives to Shipshawana and picks him up and takes him to work in Mendon. And I said, boy, that's a zigzag life, but